Hello and welcome back to the Tingen Law YouTube channel. My name is Jacob Tingen and I'm an immigration attorney and the managing partner here at the firm. Today, we're going to talk about the asylum application process, and we're going to break it down into the different ways that you might find yourself applying for asylum if you're an immigrant to the US. This video is going to be available in English and also Spanish, and I'm very excited to share with you this information because I think it can be very helpful for you. So if this is a topic that is important to you or to someone you love, share it with them, and we look forward to seeing you here on this video. Feel free to comment, and we'll be responding to questions in later videos as well. When we talk about the asylum application process, there are a couple of different scenarios where you might find yourself applying for asylum, and we're going to talk about each of these scenarios in this video. We're going to talk about the affirmative asylum application process. We're going to talk about how you can file an application defensively, and then we'll also talk about some special cases such as if you're an unaccompanied minor child, or if you know someone who is classified as an unaccompanied minor child, or even some other special cases that exist today just kind of procedurally in terms of that asylum application process. When we talk about the asylum application, that's form I-589. So the I-589 is the asylum application. It's freely available. You can download it at uscis.gov/I-589. And there you can find the USCIS information page about this government form. You can download it, you can take a look at it, you can get familiar with it. Again, we cover that in a separate video. But importantly, when you apply for asylum, you have to apply within 1 year of your arrival to the United States, or you have to qualify for some kind of changed or extraordinary circumstance. And even when you do, you usually have to file within a short period of time of that changed or extraordinary circumstance. And so there is this 1 year time limit. Now, we're going to start our conversation talking about the affirmative asylum process, which again, you need to file within 1 year of your arrival to the US. A very common scenario is someone might come in on a visitor's visa, and then there's some kind of change in the country conditions, something that makes them afraid to return to their country, or perhaps they engage in political activity here in the United States, and there's some difficulty in their home country that now that political activity, that political involvement in the US has put them in danger in their home country, or there's a coup, or there's some other kind of progress, there's a threat against family members. And so these circumstances suddenly lead to the person who's entered the United States to have a fear of returning to the US. Sometimes there's even people who come on a visitor's visa who have been threatened in their home country, and they're just hoping that things will calm down. And then when they're in the US, they realize, wait, I have options, and so I'm going to apply for asylum. So if that's you, if that's your scenario, you've entered the United States lawfully, or even if you've entered the United States unlawfully and you weren't apprehended at the border, within 1 year of your arrival, if you file for asylum, that is an affirmative asylum application. You file it with the asylum office. And where you would file that, again, you'd go to that URL, uscis.gov/I-589. You can look up the filing address. You send your application in, and that's it. That's the process. Eventually, you'll receive a notice to go and have your fingerprints taken. The government will collect biometric information. They'll make sure that you don't have some kind of criminal history. They'll do a background check. And then ultimately, they will schedule an interview. How long will this take? That depends on different administrative priorities. We saw that during the Trump admin, they were worried about people filing simply because they knew it would take years before we got around to an interview on their application. And so they started doing a first in, first out interview process where if you filed, they interviewed you inside of like, say, 6 weeks. On the other hand, I have clients that filed their asylum application back in 2012 and are still waiting on an interview. And so you need to just keep that in mind in terms of how long you will be waiting for your asylum interview. It could be very, very long. And to say that it could take a decade or more is no exaggeration. So that's the affirmative asylum process. You go to your interview. If you're successful at that interview, then you receive asylum. And then within a year of that, you can apply for a green card. If they deny you, if they deny asylum, you're not denied asylum and then you go back to your life. That's not usually what happens. What tends to happen is they will then refer you to the immigration court. Break into the defensive asylum application process. This is different from those who just enter the United States. They don't have any kind of removal proceedings. They don't have any time pressures on them to make them apply for asylum. Rather, they entered. Conditions are such that they realized, hey, I need to apply for asylum. I need protection because I can't go back home. So a lot of people who find themselves filing defensively are those who have been apprehended at the border, whether they crossed without authorization or whether or not they came across at a port of entry and were interviewed. Initially, what happens to you when you come up to the border and they're like, do you have a visa or paperwork? And you're like, no, but I can't go back because they'll kill me, is they can pull you aside and they can give you what's known as a credible fear interview. Additionally, if you come across without authorization and they apprehend you, they'll pull you aside and they'll give you what's known as a credible fear interview. And that basically establishes whether or not you have a fear of returning to your country, whether there's a risk of harm coming to you. And if there is, we give you due process. They give you a notice to appear. They tell you to show up in court. Now, the other way you can end up in a defensive asylum application process is if you failed at the asylum office with your affirmative application, they refer it to the court. When they refer your case to the court, they will also at that point mail you or issue you a notice to appear. And they'll say, hey, these are the reasons that you can't remain in the United States. What are reasons that they wouldn't refer you to the immigration court? Let's say you had some other kind of lawful status. So if you have TPS or something like that, they may not refer you to the immigration court. But generally, what we see is when an affirmative asylum application is denied, they send you to the immigration court. You've got that notice to appear. You show up in immigration court for your first hearing. It's usually a master hearing. And at that hearing, you have the opportunity to plead to the notice to appear. You plead to factual allegations. There's also a legal charge or a statute of removability. It says this is the legal justification we have to remove you from the country. You have to respond to that. And you have to say, well, these allegations are true. I guess I am removable. And then at that point, the question becomes, well, how are you going to defend from removal? And then at that point, you can say, well, I've got an asylum application that I would like to use to defend from removal from the United States. And that's generally the process. It's the same application. You would go to uscis.gov/I-589. You would download the application. You would fill it out. You would present it in court. And then after that master hearing, when you've presented that asylum application, you can have multiple master hearings, but usually if that's what happens at that first hearing, you've pled to the NTA, you've presented an application, they will set a hearing date for your individual hearing. And between the time of your initial application and that individual hearing, you have the opportunity to submit more evidence. That evidence tends to be, and again, you would do this with your affirmative application. So if you were referred from the asylum office, maybe you have it all together, maybe you don't, or maybe new evidence has come forth that strengthens your claim. And so you would put together an affidavit of your own. You would get additional evidence, maybe declarations and statements from other people, police reports, anything that would strengthen your claim. Usually we also include country conditions evidence that shows, hey, look, all of these news articles, the Department of State has prepared reports on the country conditions, and we know that this is really dangerous. And so we can't deport this person to these conditions where they're likely to be harmed. Then at the individual hearing, it's an interview. Your attorney gets an opportunity to interview you. The government attorney, who is an adversary, we have an adversarial justice system, so their job is to oppose your asylum application. They will ask you questions about your asylum application, about your sworn statement, about your evidence, to see if you're telling the truth, to see if you're credible. And the judge is evaluating this the entire time, and then the judge issues a decision. Now, I want to talk about a couple of special cases because I mentioned that you'd have defensive application opportunities if you're served with a notice to appear. Let's say you come into the country without legal status, or you approach a port of entry and you say, I can't go back because they'll kill me. There's also the option where you actually enter with a visa and they interview you at the airport maybe, and they realize, or you tell them, hey, I'm going to apply for asylum. That's technically a violation of your visitor visa status if you come with the intention to stay and apply for asylum because you have a visitor's visa. So it's a whole other ball of wax. But my point is this: there are some special circumstances that might apply depending on what happens next, or maybe even what happened before. So I'm going to talk about a couple of these things. The first thing I want to talk about is, what if you're an unaccompanied minor child? So if you're under the age of 18 and you come across the United States border and you're apprehended, and you're not accompanied by any adults or any parents, then you are considered an unaccompanied minor child. And so some special rules apply to you. There's the TVPRA. It's a special law that says that, hey, if you're an unaccompanied minor child, if that's how you've been classified upon your entry to the United States, you get to have the asylum office look at your asylum application first. Okay? So even if you're in court, you would go to court, you would plead to the notice to appear, you would present the asylum application and say, Your Honor, this person is an unaccompanied minor child. We'd like to close this case out or at least put it on pause while we file with the asylum office. And so that's one kind of special scenario. And then, of course, if you win at the asylum office, congratulations. And if you don't, it can get referred back to the immigration court. But usually if you've come across as a minor child, there are potentially some other options that you can take advantage of. And so you'd want to talk to a lawyer and make sure that you're on track there. Another special case that I would say is offered frequently is, and this has to do more with like changing administrative preferences from one presidential administration to the other. In some of our other videos, we talk about the wide power that the executive branch of the US government has over immigration policy and procedure. And so each time we get a new president, they have new priorities about who should be deported and who should not. And that frequently leads to a lot of court shuffling and policies over whether or not it's worth it to spend resources on deporting people who don't have criminal records, who've already been here 5 years, because as I've mentioned, with over 2 million cases on the immigration court's docket, they don't always get to everybody's case in a timely manner. I just had a case recently that started in 2013 and just got resolved a couple of weeks ago. And so this happens all the time. If you've been in the US a very long time and they haven't heard your asylum case, then they might be willing to exercise prosecutorial discretion. And this is something that the government attorney can offer to you and say, hey, you don't have a criminal record. We see that you have US citizen children. We see that you have a life here. And given that you don't have a criminal record and you seem to be contributing to society here in the US, we're not going to expend any resources on deporting somebody like you. We'll give you the chance to close out your case. Sometimes in that situation, you can even refile asylum with the asylum office and start the process there with an affirmative application, which can be advantageous because, like I said, in the court context, it's an adversarial justice system. Somebody's job is to oppose your application. In the asylum office, nobody's job is to oppose your application. It's more neutral, okay? And so there are opportunities to have greater success at the asylum office than you might encounter in the immigration court. So there you have it. We've talked about the different kind of procedural approaches to applying for asylum in the US. We've got affirmative applications, defensive applications, and then special situations that might apply to you. I highly recommend, because asylum can be so technical, that you do hire an attorney to help you through both the procedure of filing for asylum and the law, the legal aspects. Make sure that you have the true legal basis to have a strong asylum claim. No attorney can guarantee you a win, but we can make sure that you're as prepared as you want to be, because if your life depends on it, and if you're applying for asylum, you're saying it does, you want to get it right. And so it's very important that you follow these procedural rules and these legal rules to the letter. Thank you for watching this video. It's been a pleasure to visit with you and talk about asylum and our asylum processes. I hope that this information has been helpful for you. And before we end, I want to encourage you to like and subscribe. Make sure you come back and visit us at the Tingen Law YouTube channel frequently, where we frequently post updates about immigration, business, and IP. We will see you around, and thank you once again.